Hi, everyone, and welcome to the Network for Public Health Law's webinar entitled Dobbs v. Jackson Women's Health Organization, the New Reproductive Health Landscape. My name is Summer Gates, and I'm an MD-JD student and legal researcher at the Network for Public Health Law, Western Region Office, and I will be the moderator for today. There is a question and answer function in the Zoom, and we encourage you to send your questions as you think of them during the presentation, as you'll be monitoring them. At the end of the substantive presentation, we will be able to address as many questions as time allows. Today's presenters are Jennifer Pyatt, who is the Deputy Director for the Network for Public Health Law, Western Region Office, and Erica White, who is a staff attorney for the Network, Western Region Office as well. And I'll pass it on to Jen now to begin her presentation.
Thank you, Summer, and good morning, everybody. Good afternoon to those of you who are on the East Coast. My name is Jen Pyatt, as Summer mentioned, Deputy Director of the Network's Western Region Office, housed in sunny Phoenix, Arizona. Without further ado, let's jump into the substance of today's webinar. Today, we're going to discuss the Dobbs decision and its legal impacts, alternate litigation that's emerging nationally to protect reproductive health access, and current legislative and executive approaches, primarily focusing on those approaches designed to promote reproductive health and access. Next slide. So we'll start, of course, with the breakdown of the court's Dobbs decision. And in order to discuss that decision fully, we really do need to start with a brief discussion of the cases that it overturned, Roe versus Wade and Planned Parenthood versus Casey. So in 1973, the US Supreme Court in Roe versus Wade, of course, guaranteed the individual constitutional right to abortion. The court created a trimester framework. We don't need to discuss that framework in detail today. Really, what I want to pull away from the Roe decision for today's discussion is that in the Roe decision, the court drew a line at viability. Viability is typically understood as the point at which a fetus can survive outside the womb. And with today's technology, that's at roughly 24 weeks of gestation. So Roe announced that before viability, states could not ban abortion. The Constitution, likely via the 14th Amendment's privacy-based protections, ensured that up until viability, pregnant individuals could make the decision for themselves about whether to carry a pregnancy to term. And after viability, states could regulate abortion, even to the point of banning the procedure. And the court in this way balanced a pregnant person's right to privacy, bodily autonomy, against the state's interest in the potential child. So in Casey, in 1992, the Supreme Court was confronted with a challenge to Roe, to the right, and chose to uphold Roe's viability line and affirm, yes, there is a constitutional right to abortion. Casey, though, introduced a new framework for assessing state regulation with respect to abortion, while states still could not ban abortions before viability. The court reasoned that states could regulate the procedure so long as those regulations did not impose an undue burden or place a substantial obstacle in the path of the person seeking an abortion. So these two cases prevented states from enforcing laws fully banning abortion until Dobbs. Next slide. So this is just a very brief introductory timeline of how the case in Dobbs came to be. In 2018, Mississippi's state legislature passed a law banning abortions after 15 weeks gestation, except in cases of severe fetal abnormality or medical emergency. And we just come off of talking about the viability line, and this clearly violates that line, banning abortions in the state before that 24 weeks period. So the Federal District Court and the Fifth Circuit Court of Appeals both found the law unconstitutional under Roe and Casey, and Mississippi then appealed that decision to the US Supreme Court. The court kept the case pending on the calendar, neither accepting or rejecting review until after the confirmation of Justice Amy Coney Barrett to the court. And at that point, In May 2021, the Supreme Court agreed to take up the case. In December 2021, the Supreme Court held oral arguments in the case, and it issued its decision on June 24th, 2022, overturning Roe and Casey. Next slide. So let's turn now to a brief assessment of the Dobbs decision. First, we'll start off with the court's constitutional interpretation based on the text of the Constitution and the court's assessment of history. Then we'll turn to the court's justifications for rejecting stare decisis, overturning precedent. And finally, we'll take a look at the new standard that the court set in Dobbs. Next slide. So the court's constitutional analysis can rightly be termed as an originalist, textualist analysis of the Constitution. The court assessed the black and white language of the Constitution and then made its own assessment of US history to come to the conclusion that abortion is not a fundamental right. With respect to the Constitution's text, the court hinged part of its assessment on the fact that the term abortion does not appear in the Constitution. And where a right is not expressly mentioned in the text, the court looks to whether a right is deeply rooted in the nation's history and traditions, sufficient to make it a fundamental right. So the court then took this path and through its own historical analysis, determined that abortion was not such a right. It rested on things like the criminalization of abortions at common law after quickening or after movement in the womb, and abortion restrictions that had begun circulating across the United States in the 19th century. And the court, firmly rooted itself to this movement, which coincided with, it was around the same time of ratification of the 14th Amendment, upon which those privacy protections are what Roe was built upon. Next slide. So I do want to pause for just one brief moment here to fully consider the scope of the court's reversal here. Mississippi, when it initially sought review, it challenged the viability line, specifically the viability line. The question presented to and accepted by the court for review was whether all pre-viability prohibitions on elective abortions are unconstitutional. And why is this important? Well, in essence, the court could have made a narrower determination on the viability line to answer the question it was asked. But the court went beyond that, fully overturning Roe and Casey, announcing that there is no constitutional right to abortion. The court even went so far in its decision as to reject equal protection as a basis for the right, which was not argued, briefed, or presented to the court. Next slide. So another question that we need to address is how the court specifically justified its reversal of prior Supreme Court precedent. Of course, we know Roe versus Wade is a decision that came from the US Supreme Court and was in fact previously affirmed by Casey. So in effect, you have this, this precedent built upon precedent sort of circumstance. Generally, precedent is relied upon. Principles of stare decisis, or standing by things that have already been decided, counsel against overturning prior case law without sufficient reason. So the Dobbs court, in this part of the opinion, went through an analysis of 5 different reasons why it believed it should reject Casey and Roe's previous analyses and overturn them. So first, the Dobbs court pointed out the nature of the error, arguing that Roe wrongly removed the issue of abortion from the democratic process. Second, the court pointed to the quality of the reasoning in Roe, going so far as to say it was egregiously wrong from the start and that it was more legislative than judicial. Third, the court looked at the workability of Roe and Casey, arguing that the undue burden standard presented by Casey was too malleable and therefore not clear and workable. Fourth, the court looked at the disruptive effect of Roe and Casey on other areas of law, suggesting that the court's abortion cases had in fact infringed on or muddied the waters with respect to other legal issues. And finally, the court reasoned that there were no concrete reliance interests affected, because abortions, as the court reasoned, are traditionally unplanned, and essentially arguing that family planning could shift to accommodate for the new legal landscape. Next slide. So the court then moved on to assess the new standard applicable to abortion in the absence of Roe and Casey. Now, as with other substantive due process rights, rights established, via the 14th Amendment's substantive due process protections, rights which are not considered fundamental under the Constitution implicate only rational basis review. So this means that a law needs only to be rationally related to a legitimate government interest in order to be upheld. And the court then went further to spell out a series of different examples of what it believed these legitimate interests could include. These include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. So in essence, the court is really here actually affirming these specific reasons underlying state laws regarding abortion. Next slide. So I do want to, in assessing the potential impacts of this decision on other areas of constitutional law, I want to turn back to the constitutional analysis at play here for a moment. As we discussed earlier, abortion does not appear in the text of the Constitution, and that was one of the Dobbs Court's major gripes. But another term that does not appear in the Constitution, and which the Dobbs Court acknowledged does not appear in the Constitution, and upon which Roe and a number of other precedents are based, is privacy. So the 14th Amendment, as in Roe and Casey, does not expressly state that it protects privacy in the Constitution's text. It states that, life, liberty, property will not be infringed by the government without due process of law. But the court previously has interpreted this provision, other provisions, the nature of the Constitution in general, to guarantee the right to privacy as interwoven within the fabric of the document. So without this protection, what else could be at risk? Next slide. 3 obvious targets include the right to marriage equality outlined in Obergefell versus Hodge, the right to contraception outlined in Griswold versus Connecticut and Eisenstadt versus Baird, and the right to privacy in sexual intimacy as announced by the court in Lawrence versus Texas. So the majority in Dobbs took great pains to argue that its decision impacted only abortion and that no doubt was cast on these other precedents. But Justice Thomas, in a concurring opinion, expressly called on the court to reconsider all of these precedents and reject them. Simply put, we anticipate litigation taking off with respect to non-textual rights like these 3 in the wake of the language of the Dobbs decision, which actually provides no real constitutional grounding for its bare assertions that this case will not affect those other cases. Next slide. And this is the tip of the iceberg in terms of additional legal arguments that may be anticipated. And I wanted to highlight another justice's concurring opinion, Justice Kavanaugh, who explained at least 2 of the potential arguments that he envisioned could be raised after this decision. One is preventing state citizens from leaving their home state to get an abortion, and the other is retroactive application of an abortion restriction or ban. And Justice Kavanaugh explained that in his view, these were easy constitutional questions dealt with through the constitutional right to travel and the ex post facto clause. But of course, these are just the opinions of one justice, and his concurrence does not provide a solid answer to these questions or a solid answer to additional circulating questions about the extraterritorial application of state laws or the risks with respect to assisted reproductive technology and IVF, among others. Next slide. So now that we've done a relatively deep dive into Dobbs, I'd like to turn it over to my great colleague, Erica White, to take us through some of the alternate litigation emerging nationally in this space. Erica?
Thank you so much, Jen and Summer, for your gracious introduction. Next slide. So we all knew that the Dobbs decision would unleash a flood of litigation. In the weeks since Dobbs, 3 types of laws have been challenged. First, many states had trigger laws on the books that immediately or almost immediately went into effect when Roe was no longer the law of the land. And second, some states, and in many cases states that also have trigger laws, laws that predate Roe may be enforced again for the first time in decades or even centuries. Third, abortion restrictions that didn't pass Roe's standard previously are up for debate again. So in the states you see represented on screen, for example, trigger laws and pre-Roe laws were upheld and allowed to go into effect. So let's dive in. Next slide, please. Federal court challenges have not been kind to plaintiffs challenging state abortion bans or restrictive state laws. Without Roe and related precedents, federal courts don't have much to hold on to legally when evaluating state laws that would rather defer to state governments, as Dobbs indicates that they should. South Carolina and Tennessee, for example, were allowed to implement their restrictive abortion laws by federal district and appellate courts. Next slide, please. State court challenges are where things get interesting. The majority of early challenges to state laws have focused on state constitutional challenges. In the states you see represented here on the screen, state laws restricting abortion access were challenged under state constitutions. Challengers argue that the state constitutions contain inherent rights to privacy extending to abortion. In Ohio, for example, advocates argue that Ohio's constitution contains even greater protections than the federal constitution. However, that argument didn't succeed, at least not initially, and the law was allowed to go into effect. In some states, such as Kentucky, Louisiana, Idaho, and Utah, you can see here, the state abortion laws were halted pending litigation. In other states where I've indicated challenges have, quote, failed, state courts declared that the state constitutions didn't contain protections for privacy or abortion or dodged the issue and allowed the laws to go into effect pending appeals. Next slide. So let's take a closer look. Let's start in Florida. At first, the state's restrictive abortion law banning the procedure after 15 weeks of pregnancy was blocked by a state judge in late June. According to this judge, the law violates privacy protections in the Florida Constitution. And in fact, the Florida Constitution was amended in 1980 to include a right to be left alone and free from governmental intrusion into private life. And in 1989, the Florida Supreme Court explicitly linked that state private constitution privacy right to include a right to abortion. The court went further and said that even if the US Supreme Court were to recede from Roe, as it did in Dobbs, the state's privacy amendment in that constitution would protect abortion rights in Florida. But as we learned in Dobbs, precedent is not set in stone. In fact, the Florida abortion law here was almost immediately put back into effect when the state attorney general appealed that lower court's decision to halt the law from going into effect. The challenge seems headed straight to the state Supreme Court. And in the meantime, the law is in effect. Next slide. Mississippi doesn't have explicit protections in its constitution, but that was the legal challenge posited against the state's trigger law by the only abortion clinic in Mississippi, which is the same clinic involved in Dobbs. So here, the lawsuit against the trigger law cited a 1998 Mississippi Supreme Court ruling that said that the state constitution invokes the right to privacy that includes an implied right to choose whether or not to have an abortion. The state attorney general's office, who's defending the law, argued that the 1998 ruling was rooted in Roe when Planned Parenthood v. Casey, so no longer good legal reasoning. But the clinic retorts that the state justices in that 1998 ruling never said that their ruling was based off the federal constitution. But regardless, on Tuesday, July 5th, a state judge held that the challengers weren't likely to succeed on that claim under the state's constitution and declined to block the trigger law. So it's going into effect during appeals. So this decision, along with Florida, the one in Florida, and then others in other states, demonstrates trends that we're seeing in these early state constitution-based challenges to abortion laws. They haven't been tested legally until now, but in coming days and weeks, outcomes will probably vary and depend on different factors such as the type of challenge, the specific text of the state constitution, precedent, and other factors. Next slide, please. Some states, however, have explicitly protected abortion in their state constitutions. So this piece, which is available on our network website, we analyzed state constitutions and we found 9 states whose Supreme Courts found their state constitutions protect abortion rights. Next slide, please. So here are those 9 states, kind of an interesting assortment, right? State courts' reasonings protecting abortion within constitutions vary. So some courts rely on Roe, some rely on the explicit language of their state constitution, some rely on a combination. Just to give you a few examples, there's a 1997 case where the Alaska Supreme Court held that, quote, reproductive rights are fundamental and that they're encompassed within the right to privacy expressed in Article 1. And then in Florida, in California, in a 1969 California Supreme Court holding, it explicitly protects the fundamental right of the woman to choose whether or not to bear children. So you can please check out our network resource for more information. Next slide. So we know that state constitutions can be an avenue to protect abortion rights. And that's what Michigan Governor Gretchen Whitmer is doing right now. So this spring, she sued to preemptively challenge a 1931 Michigan law in the books that makes abortion a felony. And at the same time, Governor Whitmer is also asking the Supreme Court, the Michigan Supreme Court, to recognize the right to abortion in the state constitution. And then on June 27th, shortly after the Dobbs decision came out, she sent another notice to the state Supreme Court and again asking them to consider her arguments. She said there is uncertainty and confusion about the legal landscape post-Dobbs, where now abortions are a felony in her state. And regarding the state constitution, she argues that the right to an abortion should be recognized under the due process clause of the Michigan Constitution, and that the criminal abortion law violates the state's equal protection clause, and that it denies women equal rights because the law was, quote, the law was adopted to reinforce antiquated notions of the proper role for women in society. And in the meantime, the law is on hold while the challenge is litigated. Next slide. So now let's look at a few different types of challenges. Many states, including Iowa and Wisconsin, as we'll see on the next slide, have multiple, quote, tiers of abortion restrictions. Iowa Governor Kim Reynolds asked the state Supreme Court to reinstate a so-called fetal heartbeat law that she signed into effect in 2018. Now, that law was never enforced. Shortly after she did sign it, a state court held it was unconstitutional under the Iowa Constitution. So why is she bringing it back up again? Well, the Iowa Supreme Court had held that abortion rights were strongly protected in the state's constitution, but that did change. On June 17th of this year, the state Supreme Court overturned that decision, and they reversed a lower court decision overturning another abortion law requiring a waiting period between an initial appointment and getting the procedure. However, the legal standard for abortion restrictions in the state was not clearly defined in the court's reasoning. So each level of abortion law may need to be relitigated to determine what the contours are in the state. Next slide, please. Wisconsin also has multiple tiers of laws. And in Wisconsin, the state attorney general sued, challenging the state's abortion ban, which is from before Wisconsin was even a state. He argues that the times have changed. The pre-Roe, and in fact pre-Civil War law in question, conflicts with other Wisconsin laws that are now in the books, specifically some passed in the 80s. These differences specifically concern fetal viability. He's arguing that the old law doesn't take into consideration modern medicine and values and the way modern people think. The statutes passed in the 1980s supersede the ban, he says, and are more reflective of modern ways of thinking. The old law shouldn't be enforced, it's obsolete. The people of the state wouldn't have consented to this law anyway. Meanwhile, while his argument plays out in court, the law is on hold. Next slide, please. Louisiana is a little bit different. Challengers are going to have some difficulty arguing that trigger laws and other restrictions violate the state constitution and civil rights that it provides for. Why? Well, in 2020, Louisiana voters approved a ballot measure that stated that, quote, nothing in this constitution shall be construed to secure or protect a right to abortion. So that avenue may be out. The state's constitution may not be a legal avenue for securing abortion rights. Instead, challengers argue that the state abortion laws are unlawfully vague and they fail to state exactly what activities are prohibited. It's not even clear which laws the state intends to enforce. And these arguments worked. That law is on hold, at least until a hearing that's scheduled for tomorrow, July 8th. Next slide, please. I'll conclude by turning to other litigation areas. Gen Biopro is a manufacturer of generic mifepristone, which is one of the 2 drugs involved in medical abortions. The company sued the state of Mississippi in 2020, arguing that the state's laws restricting sales and use of medication abortion is unlawful because the drugs are regulated by the FDA, and that federal regulation preempts state regulation. FDA has developed rules for dispensing and prescribing the drug. Mississippi's rules are much stricter. For example, in Mississippi, only a licensed physician can prescribe the drug, and they have to do that in person. FDA says, however, that any certified health provider, including nurse practitioners and physician assistants, can prescribe the drug, and patients can take it in the privacy and comfort of their own homes. On the latest hearing in this case, which took place July 1st after Dobbs, Gen Biopro argued that FDA's approval of the drug and FDA's carefully crafted regulation should override any conflicting state laws. And that challenge is ongoing. This challenge is indicative of another issue that's sure to be litigated post-Dobbs. Now that states are free to restrict abortion, which activities count as abortion? Where are the lines drawn between where the states and the federal government can regulate? We're sure to see more litigation about this soon. Next slide, please. So finally, let's turn to one more challenge from Florida. A synagogue in Florida filed a lawsuit in early June arguing that restricting abortion to 15 weeks violates not only rights to privacy in the state constitution, as we discussed earlier, but freedom of religion under the federal constitution. And this lawsuit argues that in Jewish law, abortion is required if necessary to protect the health, mental, or physical well-being of the woman. This argument may be tenuous because under traditional federal religious protections, activities done for religious purposes are generally inside that scope, but not necessarily activities that your religion permits. This novel challenge, though, is a first look at different types of legal arguments that we can expect to protect abortion access in the states. So now I'll turn it back to Jen to explore some more novel issues.
Thanks so much, Erica. So now that we've talked about some of the litigation, I think it's helpful to dive into just an approach to what the landscape looks like right now. And that landscape is changing by the day. So I do want to put that sort of caveat out there that we are continuing to follow these changes. Next slide, please. And I do also want to fully acknowledge here the efforts of the Guttmacher Institute in tracking and updating an interactive map on U.S. abortion policies and access after Roe. Their map is up to date and color-coded to illustrate the range of policies in play from the most restrictive to the most protective. So I'd highly encourage those who are interested to go and check it out. So let's go ahead and jump into some of the specifics. Next slide. Actions against abortion. Next slide. So I'm focusing here on complete abortion bans. In terms of action against abortion, we're starting to see more bans become effective in more and more states as of the time of this presentation. In fact, the slide on the screen is actually already dated. It should read 9 states instead of 8, which are either enforcing or currently able to enforce complete abortion bans. Alabama, Arkansas, Missouri, Mississippi, Oklahoma, South Dakota, Texas, Wisconsin, and West Virginia. Mississippi's not on the slide, but its trigger ban went into effect today. And a number of other state trigger bans will follow. I've included West Virginia and Wisconsin here for purposes of discussion, though things are a bit up in the air in both states at the moment. Both of these states' laws were passed in 1849. And Erica talked a bit already about Wisconsin and what's going on there, but it's a very interesting set of circumstances where the governor initially came out and announced that he would offer clemency for any persons prosecuted under that pre-Civil War law amidst attempts to block it. West Virginia's law was previously blocked, but only preliminarily. And a legal analysis recently issued by the state's attorney general has requested that the legislature specify what acts and who should be criminally prosecuted pursuant to that law. For example, whether the pregnant individual should be subject to prosecution. So in these states, the punishments with respect to these laws can be quite substantial. Terms of imprisonment range from 2 years to 99 years. Fines range from $1,000 to $100,000. Several additional states, of course, have passed trigger laws, which were set to become effective 15 days or 30 days after Roe's overturning. Those include North Dakota, Tennessee, Idaho, Wyoming. So essentially, as we continue to move further and further out from the Dobbs decision, we can expect additional restrictions in additional states to come into play. Next slide. Now, I'd like to turn our focus as we sort of move into concluding this webinar and then move into the Q&A session to actions that we've seen this year, mostly actions that have taken place after the Dobbs draft opinion was leaked in early May to finalize our discussion on the current landscape. Because of time limitations today, this is not meant to be an exhaustive list of all efforts being undertaken, but rather a small sampling. So starting with a legislative overview of actions that support access to reproductive health services and abortion, the first state we'll take a look at is New York. Next slide. So I'm sure many of you on this call remember that a leaked draft of the Dobbs decision was published well before the final version was published back in early May 2nd, 2022. Since that draft decision was published, legislators in New York have passed a number of bills to promote access to abortion and reproductive health care and to protect reproductive health services in the state. So first, New York passed a bill prohibiting licensure misconduct findings in New York for providers providing abortions to out-of-state patients. New York has also passed a law to prohibit adverse malpractice insurance actions relating to the provision of reproductive health services and has established a cause of action for those unlawfully interfering with the rights of reproductive health care. New York also passed laws extending address confidentiality to reproductive health providers and blocking New York State participation in out-of-state civil or criminal cases, for example, by refusing extradition or not honoring out-of-state subpoenas. Next slide. Additional states have taken action, and the focus of this slide is action honed in on state Medicaid programs. For example, in Maryland, a law was passed over the governor's veto, which does several things. It expands abortion provider categories, allowing nurse practitioners, nurse midwives, and physician assistants to perform abortions in addition to physicians. It also establishes the abortion care clinical training program, funded at $3.5 million annually, to ensure that there are a sufficient number of health professionals to provide abortion care. And it requires private insurers to cover abortion and requires matching Medicaid coverage without cost sharing. In Oregon, a law signed in March empowers the Oregon Health Authority to fund reproductive health services and education. And a law signed in April allocated $15 million to OHA for reproductive health equity. And I do want to mention here, I said this list was not exhaustive, but California and New York are also states that have passed bills prohibiting cost sharing for abortion services. Next slide. In Connecticut, a law signed in May 2022, actually signed right after the leak of the draft decision, provides damages and attorney's fees to persons sued for providing reproductive health services. It also prevents prosecution or assistance in proceedings related to out-of-state persons receiving those services in Connecticut, and it expands medication abortion provider categories to include advanced practice registered nurses, nurse midwives, and physician assistants. Next slide. So let's switch gears now to talk about executive pro-abortion actions. Next slide. Massachusetts Governor Charlie Baker issued Executive Order 600 on June 24th, 2022, preventing Massachusetts agencies from assisting out-of-state abortion investigations or proceedings, ensuring licensure boards work to protect licensees from discipline based on actions taken in other states for providing reproductive health services, and refusing to extradite persons to other states for reproductive health-related crimes. Next slide. Similarly, Governor Tim Walz in Minnesota issued an order on June 25th, which requires state agencies to coordinate to protect the provision of reproductive health care services in the state, to prevent state agencies from assisting other state investigations or proceedings related to repro health, and refusing to extradite. Next slide. Finally, New Mexico's Governor Michelle Lujan Grisham issued an order on June 27th to prevent state agency assistance with investigations or proceedings in other states relating to the provision of reproductive health services, to ensure against discipline from New Mexico licensing boards with respect to other states' actions concerning those reproductive services, and refusing extradite. Next slide. I also wanted to quickly discuss California, Oregon, and Washington's multi-state commitment to reproductive freedom, signed by the governors of all three states on June 24th, 2022. So this agreement vows to protect against hostile state efforts and cooperation with the same, refuse extradition, protect against medical record misuse and adverse liability insurance actions, support legislation to protect professionals from license and discipline, expand access to abortion services, and defend against misinformation. Next slide. So before we jump right into the Q&A, I wanted to acknowledge a few of the interesting state constitutional movements we're seeing as well. So as Erica previously mentioned, 9 state Supreme Courts have interpreted their state constitutions to protect a right to abortion. But as we're all well aware, after Dobbs, precedent, it can change. Precedent is not set in stone. And so what we've actually seen are efforts being undertaken currently in at least 7 different states to explicitly amend state constitutions with language protecting reproductive liberties. At this point, Vermont is the only state so far to have a confirmed measure on the ballot in November 2022. So that's moving forward, but this information would be incomplete without also sharing, of course, that efforts are underway in several different states to eliminate abortion from state constitutional protection via constitutional amendments, including states like Kansas and Kentucky. So on behalf of my co-panelist and moderator, we certainly hope this information has provided a helpful snapshot of the legal landscape in the US today post-Dobbs. And with that, I will turn it over to Summer to launch us into the Q&A. So Summer, next slide.
Okay, so for our first question, we have, considering the implications of this court case, what is the likelihood of women maternal health being considered as a threat to public health?
I'll just jump in. This is absolutely a threat to public health. Women will die from the Dobbs decision. Leaving states the ability to define abortion just puts a lot at stake. For example, some Catholic hospitals consider an ectopic pregnancy. They will not just, they'll just remove the entire fallopian tube because they will just operating other ways that consider that abortion. So letting states make these decisions, this puts women's health at risk. This will affect different racial demographics differently. This is going to affect people of color, women of color a lot more. People who don't have have the resources to get to other states where they could access life-saving care. This absolutely is a threat to public health.
Yeah, and I'll just add to that. An article was published recently in Demographics that assesses sort of the projected impacts of fully disallowing all desired abortions. So of course, you have to factor into that analysis that some states will still continue to provide abortions after this decision. But with that analysis conducted, the findings suggested that after the first year of a ban, maternal mortality would rise by 21%. And in non-Hispanic African-American populations, it would rise by 33%. And that's just by virtue of continuing a pregnancy. Pregnancy is dangerous. Pregnancy causes death. Our rates of maternal mortality in the United States are abysmal when compared with other industrialized nations. And that study, I think, indicates, the potential outcomes. And just to clarify one more piece of it here, that study did not account for unsafe abortions, unsafe procedures. It simply accounted for the change of continuing a pregnancy and increased mortality that would result from no person getting an abortion that they wanted versus people continuing to get abortions that they would seek.
The next question is, when you refer to complete abortion bans, do you mean no exceptions, including health of mother, incest, rape?
That is a good question. And that question is state specific. So the complete abortion bans, I mean abortion bans, not at 6 weeks, not at 15 weeks, not at 8 weeks, but bans. But there may be specific exceptions as outlined in those laws. For example, an exception to protect the life of the mother, medical emergency, those are showing up in these bills. But what is starting to not show up in these bills or in these laws are exceptions for rape or incest. So South Dakota, West Virginia, Texas, they all have language that does not provide for exceptions for rape or incest, but it will be a state-specific issue.
Yeah, I agree with Jen. This does vary state by state. I think colloquially, when you say a complete abortion ban, that means no exceptions at all. But isn't it the same thing in a state that only allows these very narrow exceptions where it's practically a complete ban? Yeah, I agree with Jen.
Our next question is there any plausible executive action that President Biden can take to preserve abortion rights?
So we actually have posted a resource somewhat to this effect on the network's website. And if I can get a link to it while we're answering other questions, I will post a link to it in the chat, sort of addressing the potential for a public health emergency declaration with respect to the real impact to reproductive health that this decision is having. Because you can see that states that do continue to provide abortion reproductive health care services may be very, very, very isolated from other states that continue to do the same. So I'm thinking of states, for example, like Illinois, or states like New Mexico, where they are surrounded by states which are hostile. Those states may become inundated, flooded with patients seeking reproductive health care. And we've seen the impacts of health systems being flooded with patients just, these past 2 years over the course of the COVID-19 pandemic. So the potential for a public health emergency, Stafford Act emergency, if a state requests it from the president and requests aid, that could be one action that may be on the table. Erica, any additional thoughts?
Yeah, absolutely, Jen. Nicely stated. I agree. President Biden can take executive action on this issue. He can declare a public health emergency. He can do so under the Stafford Act. Governors can request that he do this. He absolutely can. He does have that power. And yes, like Jen said, I recommend you check out our network resources on this subject where we have laid it out and you can read about it in detail. But he does have these powers, and there's a lot of things that this opens up the door. He could expand and protect access to mifepristone. He could relax licensure requirements and other regulations that can be relaxed to allow more people to access the care that they need. So this is an authority that we have on the table. Thanks.
Are there other areas of law where states protect against extradition, or is this novel to providing abortion care related reproductive health services in light of the Dobbs decision?
I don't know if there are other areas where states semi-uniformly have protected against extradition in this manner. That's a great question, and we can certainly provide some follow-up research to the requester, but at this moment, I don't know. It may very well be novel that so many states are taking this approach on this issue. Erica, do you have any knowledge on that?
That is a really good question, and not specifically right now. I think we will see that probably in the coming days, where states will try to reinforce their laws outside of their jurisdictions. So we may see them try to exercise these powers, but I think it's to be determined up in the air if this is going to happen.
Can or will the U.S. constitutional right to life, liberty, and property be re-argued to more explicitly encompass the right to bodily autonomy? Instead of focusing on privacy, can it just more explicitly be linked to liberty and life?
I can jump in, and then Erica, if you have any thoughts, you can add them. I certainly think that there are a number of arguments that are being made right now. There are a number of arguments that are being written about right now. I'm not convinced that this Supreme Court would entertain that argument, simply because this Supreme Court in the Dobbs analysis seems fully focused on the text of the Constitution, and the text of the US Constitution does not explicitly contain the word abortion or the right to abortion. And without that explicit text, the court then turns to, is this rooted in our nation's history? Is this rooted in our nation's traditions? And the court's conclusion in the Dobbs decision was that no, it wasn't. So I don't see that argument gaining traction in the current Supreme Court. And we've already seen that the current Supreme Court sort of try to steer away equal protection-based arguments as well, even though that was not something that was in the briefs or was argued or was raised in the case. So I don't see it happening. Erica, any thoughts?
Yeah, nicely stated, Jen. I agree. I don't see federally the Supreme Court being amenable to these kind of liberty arguments. And even at the state level right now, the state constitutional challenges, it's all very focused on that right to privacy. I think that's just because that's how we've understood abortion rights historically in this country, is it's always been linked to privacy. That's how these state constitutions largely have been sculpted, and how the language has been understood. I think the challenge of the states would be a little more amenable to that and entertain that. And I think that those arguments are likely to be made in the future.
Our next question is, what efforts are being done in states like Texas that allow unrelated third parties to bring civil suits against the providers, suits that are not covered by their medical malpractice carriers?
Yeah, that's a great question. As far as I'm aware, the Texas law is still being litigated in the state courts, and other states are adopting that strategy to regulate abortions. I think there's still more litigation in the future for this area, but Jen, do you have anything to add?
No, I don't have anything specific to add on that question.
Okay, the next question is, in states where life begins at conception, will frozen embryos previously allowed to be donated now have to be legally adopted?
I think that questions relating to reproductive assistive technology, questions relating to IVF, these are all questions that are up in the air right now. These are all questions that are somewhat unclear. Now that Dobbs has come down and deconstitutionalized the right to abortion, and undoubtedly, I think what we can expect is a lot of litigation a lot of litigation to actually feel out the contours of how far this can go. But yeah, at the moment it's up in the air. Erica?
Yeah, and that's a really interesting question too, because Dobbs has seemingly opened the door for arguments about fetal personhood, and that implicates a lot going forward. And there's this classic hypothetical law professor been throwing around, right? Of if you're in a burning building and there's a freezer full of embryos and there's a woman, like who do you say, whose life is more valuable? Because if fetal personhood is in the books now, that's a hard question to answer. But yeah, absolutely, this will be subject to litigation in the future.
Do HIPAA laws offer any protection?
So with respect to the HIPAA related question, I know that I'm gonna post in the chat here. HHS has published a guidance on the HIPAA privacy rule and disclosures of information relating to reproductive health care to sort of affirm that individuals should have confidence in that their health information is protected and should remain private. So there is this guidance. I would defer on specific data related questions though to our colleagues in the Mid-States region of the network office who work on those issues exclusively and very prominently, and I would be happy to pass on any specific questions related to HIPAA or other privacy-based protections to them. Erica, do you have anything to add?
Yeah, nothing to add, but we will have hopefully a network webinar upcoming in the next few weeks or months about this issue, particularly about data privacy. So I invite you all to come back and join us for that.
Next question is, with the expansion of licensees allowed to perform abortions and the safety concerns you just enumerated, how are states getting past the rational basis test?
I'm not entirely sure what that specific question is asking. How are state restrictions surviving the rational basis test? And I'll answer that question, which I think we're starting to see, exactly how they might be able to survive the rational basis test based on the language in the Dobbs decision. Back on that slide on that slide that enunciated essentially the Supreme Court's application of the rational basis test to abortion going forward. They have expressly laid out potential situations where the rational basis test would be satisfied. Situations like respect for and preservation of prenatal life, the protection of maternal health and safety. And just to be clear, the rational basis test in and of itself is not a test that has a lot of teeth. It is a very, very low bar to satisfy rational basis test scrutiny. But I think the fact that the Supreme Court has expressly spelled out in Dobbs, these are potential ways that states could satisfy that rational basis test going forward. I think that provides some of that, substance.
Yeah, and in the underlying context of where ideally states should weigh the state interest in regulating abortion, and then also the interest in individual rights, and when you're thinking about health and safety, is related to that. That's all really been thrown up in the air right now, because as we've discussed with these different, people will die. Just looking at projected mortality rates in the future, I don't think it's really about health and safety at this point. But it's a great question.
Are you aware of any other legal challenges to abortion bans that have been situated in other areas of the federal constitution? For example, the property clause of due process clause, 14th Amendment equal protection clauses.
I haven't seen any at the federal level, but looking at states in Michigan, Governor Whitmer is making the argument of getting right to abortion on the Michigan Constitution under equal protection. I think that these novel arguments are going to come. Right now, I think everything's very focused on privacy rights, but Jen, have you seen this?
I can't say that I've seen it as of yet. I have seen, writing, academic writing, op-ed writing, posing different kinds of arguments that could be made, including arguments based in the 13th Amendment, involuntary servitude. So there are arguments that are being illustrated, that are being written about, that are being put out there, but I haven't specifically seen it show up in a lawsuit at this moment.
We'll have time for one or two more questions. So this next one is, what do you feel are the largest implications to the sharing of patient data? Can states or health systems truly protect all reproductive health data using current systems, or is there a new solution or paradigm needed?
I think, we are certainly seeing the fallout of this decision and the anxiety and the stress regarding that data. I mean, news articles all across the United States, as soon as the decision came down, were saying, delete your period tracking apps, delete this information. But I think it certainly goes deeper than that. And I think there certainly need to be real considerations about how to ensure that patient security, patient privacy is protected moving forward, especially in circumstances where states may attempt to start applying abortion restrictions outside of state borders. And then we'll really start to see litigation taking off. So yes, I think that this moment poses some serious questions on that front. For more details, I would defer to my mid-states colleagues. Erica, do you have any thoughts on that as well?
No, great answer. Nothing to add, but yes, I do. We will address that in future webinars with specific data privacy issue. That's a whole other can of worms and a whole other webinar. But yeah, great question.
Okay, for our last question, where does Dobbs leave the doctrine of stare decisis? Can the Supreme Court ignore all precedent going further forward?
Where does it leave the doctrine of stare decisis? The Supreme Court in Dobbs has overturned Roe and has overturned Casey. And Planned Parenthood versus Casey is a case that predominantly is a case focusing on stare decisis principles. Do we respect the previous decision of the Supreme Court? The Casey court said, yes, we should. But that Casey decision, the analysis in it, that is no longer good law, according to the current Supreme Court. And in my view, the Supreme Court no longer may abide by its precedents. It may not. The Supreme Court, announced in Dobbs that this decision is limited solely to abortion and it should not affect other rights like marriage equality, like private sexual intimacy. But in saying that, it failed to give that statement any actual constitutional grounding. It didn't tie that statement to any constitutional language or command. And so I don't view that statement as setting it in stone that the court will no longer want to reconsider its other precedents in future cases as well. Erica, any last thoughts on that?
Yes, absolutely. And you pointed to the concurrences, Jen, and earlier. And for those of us who've read those, there are some truly worrying and disturbing things in those concurrences. And yes, where does this leave stare decisis? Where does this leave the rule of law? This Supreme Court wiped away 50 years of precedent and removed an individual right from Americans for the first time in history. So that's an open question at this point.
So I think at this point, we're nearing the top of the hour. Our apologies to those of you who had questions that we were not yet able to answer. Erica's email and my email are both on the screen. If you have specific questions that we weren't able to get to today and you'd like to get an answer, please email us. We'd be happy to connect with you and to address those further. Otherwise, thank you so much, everybody, for joining us today. It was a pleasure.
Yes, thank you all so much for joining us today. Great discussion.